So, the YNW Melly situation has been going on for so long that a lot of people genuinely stopped keeping up with it. And that makes sense, because every time it looks like something is about to happen, it gets pushed back, or delayed or rescheduled, and nothing actually moves. But right now, there is genuinely a lot happening all at once, and it is worth going through properly, because when you look at everything together, the picture is pretty different from what most casual coverage is showing. Start with his mom. She posted on her story that her son was coming home soon. That was the whole post. No follow-up, no explanation attached to it. She just said it and left it there. Now, on its own, that could mean anything, but the timing lined up with something real that was happening legally. His attorneys had just filed a brand new motion in court, arguing that there was additional evidence that no judge in this case had ever actually reviewed. And that, start with his mom. She posted on her story that her son was coming home soon. That was the whole post. No follow-up, no explanation attached to it. She just said it and left it there. Now, on its own, that could mean anything, but the timing lined up with something real that was happening legally. His attorneys had just filed a brand new motion in court, arguing that there was additional evidence that no judge in this case had ever actually reviewed, and that this evidence was relevant to the question of whether he should be allowed out on bond before his retrial. The filing said he was entitled to a fresh hearing because circumstances had changed and new information existed that neither the current judge nor the previous one had ever looked at. What that information actually was, they did not put in the filing. They kept it completely out of the public record. So his mom posting that he was coming home, his lawyers filing for a hearing based on undisclosed evidence, all of that hitting around the same time got people paying attention to this case again. The hearing ended up being 4 hours long. His attorneys did not just show up and argue. They came with a physical plan. They had already set up a house in Broward County where Melly could stay under supervision if the judge said yes. Armed security, no social media, barely any ability to move around freely. They basically pre-answered every question the judge might raise about whether releasing him was manageable. The legal argument itself was built around the fact that the prosecution's case has been getting weaker, not stronger, since Melly was first locked up. An appellate court had already thrown out evidence that was pulled through a search warrant the court found to be too broad. That is already a significant hit to the state. Part that his defense kept coming back to was the additional charges. Prosecutors had been holding extra charges on top of the original murder counts for over 650 days. Then the day before a scheduled retrial was supposed to start, they dropped all of them. Every single one. Gone. His attorneys made sure that did not get treated as a minor procedural thing. You do not sit on charges for nearly 2 years and abandon them the morning before trial, unless those charges were not as solid as they were being presented. The judge did not rule that day. Said he would come back with something written. While people were waiting on that, word started going around that the bond had already been denied. Melly posted from inside the jail to address it. He wrote that bond had not been denied, called it fake news, said he was still waiting, and put God first at the end. Simple post, said what it needed to say. The actual situation was that the judge had just pushed his decision to the next day, which happened to be Melly's birthday. He turned 28 in a Broward County jail cell with the ruling still pending. Not trying to make that into something dramatic. It is just a factual detail that shows how long this has been going on and what the waiting actually looks like for him personally. The written order came through a few days later, 39 pages. The judge had gone through the full case file, the evidence from the first trial, and testimony from every witness who showed up at that hearing. After all of that, the answer was still no. He wrote that the proof of guilt is evident and the presumption of guilt is great, and that the state's evidence is strong enough to convict without any material contradiction that raises a genuine question about guilt or innocence. This was the 4th time Melly has asked for bond since his arrest. Each time the answer has been the same. His attorneys put out a statement after that, and it was not soft. They said the court and the state's attorney's office should have been troubled by what was laid out at that hearing. Their client had been behind bars for over 7 years. the last three in conditions they described as dehumanizing, and he still has not been convicted of anything under the law. They said across their combined decades of legal work they had never encountered a defendant being treated the way their client has been treated. They also said other attorneys from across the legal community had reached out to them after the bond denial to say the same thing. That is not something you say publicly if you do not mean it, especially at the level these attorneys operate at. The comparison they drew in that statement is worth explaining. Around the same time this denial came down, a federal magistrate judge in a completely different and very public case publicly apologized to a defendant for time spent in solitary confinement. That defendant had been there for days. Melly's attorneys put that directly next to their client's situation, 3 years in those conditions, and pointed out that no acknowledgement of any kind had come from the court handling his case. The contrast is hard to dismiss. Now, the conditions piece of this runs as its own serious issue alongside the murder case. Since late 2021, Melly has been on a 23-1 schedule, 23 hours a day in a cell alone. The 1 hour he is allowed out, he still has no contact with other people in the facility. His phone and visitation rights were cut in 2022 and have not been given back. He has not spoken to his family since then, has not seen his mother. At one point, she stood at a press conference and spoke directly to him through the camera because it was the only way to reach him. She told him she loved him and that she was going to get him home. That is not a normal pretrial situation by any measure. The jail calls it administrative segregation, not solitary confinement. Their position is that it is a standard classification used when an inmate's presence in general population creates a safety risk to staff or other inmates. His legal team filed a federal lawsuit against the Broward Sheriff's Office over this, alleging violations across multiple constitutional amendments and describing his treatment as something that shocks the conscience. The lawsuit specifically pointed to an incident where another inmate made a claim that Melly had been planning an escape. After that, his belongings were taken and his communication was shut off entirely. His attorneys argued there was no legitimate security reason for what followed, and that what was happening to him was punitive rather than precautionary. The sheriff's office responded by saying they do not comment on pending litigation and maintained that administrative segregation is a standard housing classification. The co-defendant situation is something that does not get enough attention when people talk about this case, but it is genuinely relevant to where things stand going into the retrial. Cordell Henry, who performed under the name YNW Melly, was charged alongside Melly. Prosecutors said he helped move the bodies and set the scene up to look like a drive-by shooting, positioning himself and Melly as victims. Henry resolved his case by pleading no contest to accessory after the fact and witness tampering. The murder charges against him were dropped completely. He got a 10-year sentence. His case is done. He is already through the system. Melly, the one the state is calling the actual shooter, the one facing a potential death sentence, is still sitting in pretrial detention, waiting on a trial that starts in early next year. A jury heard the full case and deadlocked, could not reach a unanimous verdict. That means the state has to start from scratch in front of a completely new jury, except they are going in with less than they had the first time. Evidence was suppressed by an appellate court. The extra charges they carried for over 650 days were dropped before trial even started. The co-defendant, who could have been a major part of the prosecution's case in that courtroom, has already taken his deal and moved on. The state is walking into a second trial with a narrower version of what they already could not get a conviction on. His attorneys are in the opposite position. They have the suppressed evidence working in their favor. The dropped charges show a prosecution that overextended and had to pull back. The co-defendant dynamic has shifted, and there is still whatever is sitting in that March filing they deliberately kept out of public view. They have been careful about what they say publicly and what they hold back, and that is clearly a strategic choice. There are also reports circulating about surveillance involving people connected to Melly that could come up during the retrial, though that has not been officially confirmed and his team has not spoken to it publicly. What they have spoken to publicly is straightforward. They said the state failed to get a conviction the first time, and they are confident it will fail again. They said it plainly, not as a talking point. These are attorneys who have seen everything in this case from both sides and have made a professional assessment. Whether that assessment is right is what the retrial is going to answer, but it is not coming from nowhere. The full timeline of this thing is worth stepping back and looking at. Melly was arrested in early 2019. The case got delayed almost immediately by COVID. Then there was a death penalty appeal process that took years. Eventually, the first trial happened and ended in a hung jury. The retrial got scheduled, then pushed, scheduled again, pushed again. Additional charges sat over him for 650+ days, then got dropped the morning before trial. The retrial got pushed again. A new date was set, and it is now locked in for early January next year. When a verdict finally comes in on this case, Melly will have been in pre-trial detention for close to 8 years. 8 years waiting on a case. No conviction. No acquittal, just sitting there while the dates keep moving. His mom posted that he is coming home soon. His lawyers said the state cannot get this done twice. The judge wrote 39 pages saying he stays in. The co-defendant already wrapped his part of this up. The state's evidence has been cut down by appellate rulings. The extra charges are gone. A brand new jury is going to have to sit through all of this from the beginning, in a trial starting in early next year. One jury already heard everything and could not decide. That is the reality underneath all of this. 8 years of delays, suppressed evidence, dropped charges, a co-defendant who took a deal, and a man who has not spoken to his family in years. All of it is pointing toward one courtroom, one jury, and a verdict that has been getting pushed further and further down the road since this whole thing started. When it finally comes, it will be the first real answer this case has ever produced. And at this point, after everything that has happened, it is the only thing left that actually matters.